Now, after each attorney presented their case, the justices had a chance to ask them questions. Justice Sotomayor asked Mr. Clement,
It seems like most people agree if the statute uses reasonable, that Congress is delegating the definition of reasonable to the agency. And the agency is deciding what is reasonable within some outer limit, either set within the statute or within the law. But the point is that it's great rhetoric, Mr. Clement, but we do delegate. We have recognized delegations to agencies from the beginning of the founding of interpretation. And so I'm at a loss to understand where the argument comes from.
See, here we see Justice Sotomayor using the same sleight of hand that General Prelogar did. Petitioners are not questioning the agency's definition of reasonableness, but their actions without any statutory language. Remember, the law did not give discretion to the Department of Commerce when it comes to who pays the salary for the monitors. It was silent on the subject. Justice Kagan asked,
well, because you have no other option. I mean, what Chevron is it's a recognition that in certain cases you apply all those tools and the conclusion you come up with is Congress hasn't spoken to this issue. And if you had no other option, you're a court, there's a case before you, you try as hard as you can, even though you know you're basically on your own. But when Chevron comes in, when there is an agency, what Chevron says is now there are two possible decision makers. There's the agency and there's the court. And what we think is that Congress would have preferred the agency to resolve this question when congressional direction cannot be found because of the agency's expertise, because of the agency's experience, because the agency understands how this question fits within the statutory scheme. So it's not a question of the court couldn't do it. It's a question of once congressional direction can't be found, who does Congress want to do it?
It's not the role of the agencies or the courts to speak for Congress. If Congress did not speak, it did not speak. It's then up to Congress to decide if it wishes to speak on the matter. What Justice Kagan wants is to subvert the separation of powers and assume the role of medium in order to define what Congress wants. Even Congress doesn't think that's a good idea. Mr. Clement responded,
so, Justice Kagan, if we're going to talk about what Congress wants, we probably should at least avert to the fact that we do have an amicus brief in this case from the House in its institutional capacity. And it doesn't want Chevron. It's on our side of the case.
When the actor you're claiming to fill in the gaps for, or at least part of the actor, is telling you that you're wrong, that pretty much should seal the deal. Not for Justice Kagan, though.
If it doesn't want Chevron, it has total control over Chevron. It can reverse Chevron tomorrow with respect to any particular statute and with respect to statutes generally. And it hasn't. For 40 years, it has acceded to Chevron, except in super rare cases. It has basically said, this is the background rule. It gives us a stable default rule from which to write statutes, and we've accepted that.
Au contraire, Ms. Kagan. Chevron is not the creation of Congress, but of the very court you currently sit on. Yes, Congress could have passed a law that more tightly defines who decides ambiguities, and probably should have. But that would certainly take longer than tomorrow. And just what would keep the courts from simply reinterpreting Congress's intent in the future? Now, Mr. Clement responded,
fundamentally, even more problematic is if you get back to that fundamental premise of Chevron, that when there's silence or ambiguity, we know the agency wanted to delegate to the agency. That is just fictional, and it's fictional in a particular way, which is it assumes that ambiguity is ours a delegation. But ambiguity is not ours a delegation, and more often what ambiguity is, I don't have enough votes in Congress to make it clear, so I'm going to leave it ambiguous. That's how we're going to get over the bicameralism and presentment hurdle. And then we'll give it to my friends in the agency, and they'll take it from here. And that ends up with the phenomenon where we have major problems in society that aren't being solved because instead of actually doing the hard work of legislation, where you have to compromise with the other side at the risk of maybe drawing a primary challenger, you rely on an executive branch friend to do what you want. And it's not hypothetical.
Again, Mr. Clement brings us back to the point. Because of congressional laziness, even dereliction of duty, they have given up the work of actually writing complete laws, leaving the executive agencies to fill in the gaps in their legislation. While that may be the fundamental intent in some cases, it is a violation of the Constitution of the United States. By deferring all decisions to the agencies, the courts too had violated their oaths to support the Constitution. As Justice Thomas asked General Prelogar,
how do we discern delegation from statutory silence?
So, Justice Thomas, I think that it would be wrong to suggest that you can neatly categorize cases as those involving silence and those involving ambiguity. And the reason for that, I recognize that Chevron itself used both of those terms, but I think that the court was just trying to be comprehensive about those kinds of circumstances where Congress hasn't itself directly resolved an issue.
did you catch the switcheroo? Justice Thomas asked General Prelogar how to tell the difference between delegation and silence, and she switched it to silence and ambiguity. Justice Thomas's question has a very simple answer. Delegation is a positive statement, such as defined by the administrator. Silence is the absence of a statement.